So remember when Lebron James wanted to own Taco Tuesday and Ohio State University wanted to own the word the? Well, just last week, the Trademark Office said, not yet, guys. Stay tuned, I'll tell you how. So just recently, in another one of these videos, I was talking about how the sports world had given us trademark lawyers a lot of fun recently with 3 different kind of crazy trademark applications. Well, 2 of those were still pending at the time we spoke, and just the other day the Trademark Office actually answered those applications by saying no. One was for Lebron, the other was for Ohio State University. And it's interesting because in the response, and again, I think this is absolutely the correct responses from the Trademark Office, but in those responses, they talked a little bit more about why, and the answers are not the same for both. And there's a little interesting discussion, and I wanted to point those out to you. First, LeBron James. So LeBron wanted to trademark the term Taco Tuesday in a variety of social media and internet platforms. And, you know, there were a couple issues that I saw with that trademark application, one of which being if you're filing an intent to use application under Section 1B, you have to have a bona fide intent to use it under oath. And some of his spokespeople had said a little something different to ESPN. But that's not what the Trademark Office focused on. Instead, it focused in its refusal on a simple fact that Taco Tuesday is a commonplace phrase. It is a commonplace informational statement. Hey, we have tacos on Tuesday. And they cited all kinds of examples of restaurants and businesses and all sorts of different people that have used it and how that phrase has worked its way into the common vernacular across many, many different uses. And there's a basic principle in the trademark world. Remember, trademarks have to be a source identifier. They have to tell the consumer when they see that phrase, oh, that product or service or combination thereof comes from a particular source. Well, if a phrase is used commonly throughout our culture in so many different ways, it can't identify any one source. It can never function in that way. And interestingly enough, the Trademark Office said that Lebron could not overcome this refusal by extra time or putting it on the supplementary register. Those are ways that someone could acquire rights over time. And the Trademark Office said, you really can't ever acquire rights in Taco Tuesday. So, sorry Lebron, good idea. I know you got a lot of other stuff going on. Maybe one of those will work. The Ohio State University, you may recall, wanted to own the word the because they talk about the Ohio State University. And in their application, they were filing to own the word the in the categories of apparel, sportswear, shirts, hats, caps, etc. And the Trademark Office refused that application on the grounds that the samples that they submitted of use, which was like a sweatshirt with a big word THE across the front, those showed not trademark use, but ornamental use. And this is an important distinction. This comes up a lot of times and people wonder about this. So you want to put a phrase on a t-shirt. You want to put a logo on a hat. And you think, well then, therefore I've got rights. I want to get a trademark in that phrase in sportswear and in t-shirts. And what the Trademark Office says is that an ornamental use, putting something on a shirt or on a cap, does not signify that whatever that logo represents is the source of the hats, is the source of the shirts. So if you put the Ohio State University logo on a hat, that doesn't say that the hats came from Ohio State. It just says the hats came from some company and are referencing this other sports team or this other university. Same issue with the sweatshirts or the hoodies or something like that. Now, unlike with Lebron, the Trademark Office did say that perhaps they could overcome that if they could show different specimens. In other words, if they started putting the word the on a hang tag or on the packaging material, meaning the is the brand of apparel, it doesn't just appear on the shirt. That's interesting. They may be able to get over that. But there's one other issue. Somebody else had beaten them to the punch and applied for the word the in a similar area. Both of those got refused, but the one who got there first might end up with a trademark. We'll have to see. The point is this. The Trademark Office reminds us all the time. Trademarks have to be an identifier of a source of a particular set of goods and services. And if they don't function in that way, you can't own them. So keep that in mind. Trademarks, source, screen lawyer. See you soon.